Hello, my name is Suzanne Griest. I'm a partner at MPL and serve on the management committee. A significant portion of my practice is family law related, and that's what I'd like to talk to you about. The title of my presentation is Equitable Distribution. It's not 50-50. I have to assume that under the divorce code, their assets are going to be divided 50-50. In Pennsylvania, that is not the case. The divorce code provides for certain economic claims between the parties, those being counsel fees and costs, alimony, alimony pendente lite, which is alimony pending the divorce, and equitable distribution, which is what I want to talk to you about. So first, let's talk about what is equitable distribution. In my opinion, that's normally the most important economic claim that parties have. Equitable distribution is the process of dividing your stuff. And when I say stuff, I mean marital stuff. And marital stuff is defined as anything that comes into existence from the date that you get married until the date. So first, there are, however, some exceptions to that general rule. And I'll go over them right now. The first one is, if you had property before you married your spouse and you kept that property in your name alone, commingle it, you didn't put your spouse's name on it, then it's your property. It leaves with you when you separate, but your spouse has a right to make a claim for the appreciation and value of that asset. The second exception to the general rule is gifts. So if your grandmother, for example, writes a check to you every year at Christmas time for $10,000, if you put that check into a bank account into your name alone, then your husband or your spouse, I keep saying husband, I apologize, your spouse has no claim to that except for the increase in value to the date of separation. But if you took the $10,000 and you put it into the joint savings account, or you bought a vehicle in joint name, now you have commingled it and you've made it part of the marital estate. The third exception is for inherited property. So if you inherited property, again, grandma dies, now she gives you $100,000 in her estate. Again, if you put it in your name alone, it's yours. If you commingle it, it's in the pot. The last part of equitable distribution then is figuring out how it's going to be divided. We have equitable distribution, and equitable distribution means a distribution that is fair and just given the facts and circumstances of your. We have how we are to determine whether that balance is to be tipped in your favor or your spouse's favor. There are 11 factors. In summary, they are as follows: your age, your health, what number of marriage, the length of your marriage, your incomes and earning capacities, your ability to acquire assets in the future. Do you have minor children, and what is going to be the custodial arrangement, standard of living, contributions as a homemaker. Did one of you work to put the other one through school to obtain a professional degree or license? What kind of assets you have in your own right? Are you the person who came into the marriage with property that's back out there in your name alone? Do you have an expectancy of receiving money or property? When an equitable distribution claim is made, we want to look at those factors and we want to figure out what's fair for you and your individual case. What we first do is we list all the assets that the parties have that would be considered marital. The next thing we have to do is figure out what are they worth. The next thing, assets are valued at date of separation. Some assets are valued whenever a decision is made about how the assets are to be divided. If you need me or another attorney in my firm to help you with equitable distribution, please feel free to contact us.